Okay, well, good morning. Thank you for joining. This is putting together the elder law puzzle, and this is the first time I'm doing this, so I'm hoping this will go as I anticipate, but we'll learn as we go. I'm going to start the slideshow. Let me know if you guys can see it with a little thumbs up.
I'm able to see it.
Okay, thank you.
You're welcome.
All right, so this graphic is something that I put together from the National Elder Law Foundation certifies elder law attorneys. And these categories, these 12 categories, were defined by them. And I kind of just put it into a visual where I want people to understand that these things have to be connected and really examined to come to the proper solution. So I wanted to give a little bit about myself. Of course, I'm a certified elder law attorney. There's about 500 of them across the country, only 12 in Georgia. So you have to do an exam, experience requirement, references, and all that. I'm in Georgia and North Carolina. So people are not familiar sometimes with attorneys. A lot of times they're dealing with financial advisors or other people who are tax professionals that might have the ability to go across all 50 states potentially. We don't, as an attorney. We have to know our particular state's laws. And the thing I want to emphasize in this area, estate planning and elder law in particular, there are very different rules state by state. So some of the things we're going to talk about, it will make a tremendous difference if you're in Georgia, North Carolina, Florida, California, New York. So you have to really plan to talk to an attorney in that particular state to get to the proper answer. So originally, I showed you 12 areas. 6 of them are what we call the core areas. These are areas that every elder law attorney needs to know. And I'm going to walk you through these and kind of explain how they fit. So the first one, healthcare and personal planning. This is a lot of times with the advanced medical directives. Many of you may have done that. We talk about it in the sense of if you're not able to make a decision in the hospital, will someone be able to make a decision for you? If you have the document, you can name those individuals. You can name an agent. If you have a desire for how you want to have your life handled in certain situations, if you are in a what we call permanent vegetative state, or if you're in a terminal condition, you can indicate whether you want your life extended, whether you don't want your life extended, give instructions. If you don't have this document, then usually we have at each state a list of surrogates that are by statute in a certain order. So that statutory order may or may not be the order that you would want as an individual. And then also sometimes, even if you have the document, if there is a discussion amongst the hospital staff versus the agent of what the proper course of treatment is, the document might still be challenged. It might result in what we call an ethics committee review, where you have to go and challenge what the doctors and hospital staff want to do. So we definitely want to be aware of that first category. Pre-mortem legal planning, that's really what I would call estate planning. A lot of people think of estate planning as having to do with wealth. Estate planning is really just having to do with the orderly disposition of your property. The things that people think about, wills, usually we call revocable living trust, even though it says trust here, trust is so broad. Most of the time you're talking about a revocable living trust where people are focused on avoiding probate and maybe having some incapacity planning for themselves in case they have some issues later. Durable power of attorney for financial matters. So if you become incapacitated, you can have someone else make financial decisions for you, and we'll have some talk about that. And then some other things, real estate, some tax-oriented things with gifting, income, estate, and gift tax. A lot of people are familiar with taxes from the income side because they do it 1040 every year. A lot of people are not familiar with what we call wealth transfer taxes. So it's a whole different scheme. You have estate tax, gift tax, and another one that's not listed here called generation skipping taxes. Fiduciary representation. Here we have a situation where you are in a capacity to make a decision for someone else. It might be as a personal representative if they pass away. During their lifetime, you might be a trustee for their trust. You might be the guardian for their minor children. You might be guardian for them if they're an adult. Conservator and guardian. Guardian is over the person themselves. Conservator is over the property. Some states call it guardian for both roles. So North Carolina, there's a guardian of the person and guardian of the property. They're both guardians. In Georgia, we use different terms, guardian and conservator. Representative payee, that's an agency, Social Security. There's an issue people don't realize. A lot of times they think, well, if I have a durable power of attorney for finances, that will allow me to go and handle someone's Social Security. It won't. You need to go be approved as a representative payee as the agency. So we as attorneys, elder law attorneys, a lot of times we'll get calls from people who are in these roles who need advice, right? I'm the guardian over someone. What do I do? What do I have to report to the court? How do I handle certain things? Legal capacity counseling. This comes into play a lot for us as individual attorneys when someone calls our office and needs to make an appointment, and we'll go into that because we have to determine, is this person even able to do their own planning? And if they're not, sometimes the family will or a friend will file an action against them. And if you're not familiar with guardianship conservatorship proceedings, the court takes that potential of that person being stripped of their own decision-making very seriously. So they will appoint an attorney for them automatically. So some elder law attorneys, their role is to serve as a defense for anyone who has been challenged in a guardianship conservatorship proceeding. I personally don't do that, but as you'll find out, there's so many roles here in 12 different areas. No one elder law attorney can do them all. So a lot of times I might be talking to a potential client about something and then need to refer them out. Public benefits advice. This is really where you're getting to the heart of what separates an estate planning attorney from an elder law attorney. A lot of times the estate planning attorneys and elder law attorneys, we're doing the first four. We're dealing with the same documents. But once we get to that public benefit, Medicaid in particular, there's some rules of how you qualify. A lot of attorneys are not familiar with those. Social Security benefits, a lot of times people think of Social Security as from the retirement side, but for elder lawyers, we're talking about the disability side and supplemental security income. Veterans benefits, a lot of people think of veterans benefits in the sense of compensation if you're injured. A lot of times with elder lawyers, we're talking about veterans pension, which is a particular benefit trying to get money, particularly for assisted living. Special needs counseling. If you have someone who is on a public benefit that is what we call means tested, where they can't have more than a certain amount of assets, if you leave them assets, or if they say win a personal injury suit, they could potentially lose those benefits. So we have to plan to leave them assets in a certain way. If the assets are the individual's own assets, so for example, if I'm a parent and I leave those assets to the child and the child's special needs, those assets are considered the child's assets. So if the child makes a trust, it's a first party trust. If I am the parent and I want to protect that child from ever losing their benefits, those are my assets. I can leave them in the trust myself. That is a third party trust. And we'll talk about the difference. The other areas, other six, these are non-core. They'll come into play. They're certainly important, but not every elder law attorney will handle all of these or any of these really, depending on what happens in their practice. Insurance matters. A lot of times, these are things that are going to go to an insurance agent because we're not usually licensed in these areas, but we will still advise because, especially say Medigap, we're advising on Medicare. We need to talk to clients about that. Long-term care insurance, obviously we're doing elder law planning. We want to talk to them about how to potentially have a way to pay for long-term care and maybe provide some length of time to have some of our legal planning work. There's a 5-year look back, and we'll talk about that. Resident rights of advocacy. This is very important for a lot of people who, once they get into a facility, they may have issues staying there. You may have an assisted living, maybe the person's wandering, or maybe the person is came in healthy and they could go down and to the dining room and have 3 square meals at the time that the facility wanted. Then for some reason their health might have taken a turn and the facility is trying to say you can't stay here anymore because you cannot come down here and eat with the rest of us. So there's a lot of different issues that come with residents' rights we have to help people with. Housing counseling. This in particular talks about reverse mortgages, home equity conversion. Why are we talking about it? A lot of times people want to age at home and they may be, as we say, cash poor, house rich, right? So they have to figure out a way to get money to pay for their care to keep them at home. So here's a lot of times where we're counseling them on how to do that. Employment and retirement advice. We'll definitely talk to people. A lot of their assets, we'll show you later in an example what we usually get from a client in terms of how we analyze the situation. And we want to look at their assets and say, okay, if a large part of the assets may be in, say, an IRA or 401k, we need to understand the taxation of that, the rules on how to move those funds out. How do they count if you go on Medicaid, those things. Age and disability discrimination, employment, housing. This is an area I don't deal with at all. Usually this is a specialty area, but you can imagine in those 2 populations, getting, especially disability, you're very vulnerable. Age, if people think age of discrimination starts at, I don't even know what the head, I would say maybe 60 might be the age in their head, but the statute actually starts in the 40s. So there may be a broader application in age and disability discrimination than people may think. And the last category, litigation and administrative, will contests. A lot of times people come in, they say, I just want something simple. I try to advise against that because I understand the pitfalls with that. One of them is every single will has to go through probate court. Some people think they need a will to avoid going through probate court. It's the exact opposite. When you have a will must be probated. That's what probate means, to prove a will. When you probate a will, all heirs have to be notified. Some of those heirs may be people you didn't leave something to. There may be people you intentionally put in the will that you wanted to disinherit. If they aren't given what they want, they have an incentive to challenge the will. If you challenge a will as an heir, the court has to have a hearing over it. It can't ignore it. So it causes a lot of problems. Elder abuse. I wanted to point this one out. Elder abuse has 2 real prongs, financial and consumer. Consumers, more third party. You hear about home improvement scams, people calling on the phone. Back in the day, they had a lot of sweepstakes issues. That's what we're talking about when we're talking about consumer elder abuse. Financial, that's much more personal, family-oriented, where a family member might be taking advantage of the elderly person. Maybe they actually are serving a fiduciary role. Maybe they're an agent or a trustee, and they're not following the document, or they're exploiting the situation financially for themselves. And then nursing home torts, people hear about that, of course. If you have someone in a nursing home, something happens to them, bruises, other things, neglect, there's usually special attorneys, a lot of them with a personal injury background, that will handle those matters, but we'll coordinate with them on those. So that's kind of the overview on just the 12 areas. I like to have a little storytelling and scenarios when I do things because it keeps it a little bit more interesting. And my personal favorite to talk about as an example is the Brady Bunch. And the Brady Bunch is perfect because from an estate planning point of view, it's a blended family, which brings in a lot of different issues. So I assume everybody here knows the Brady Bunch, but if not, we have essentially two families that were put together. Mike Brady at the top, the father, had the three sons. Greg's the oldest, Peter, the middle one in front of him, and Bobby at the bottom. And then Carol Brady had three daughters. Jan is right above her, the youngest one, Cindy, and the oldest one, Marcia. And then the housekeeper, Alice, who was like family. That's why she's in the photo. Okay. So a simple example, and this is more of an estate planning example that most estate planning attorneys should point out to you. The thing that we have a problem with, even for estate planning attorneys, is you have a lot of attorneys who do other areas and also do wills, do trust. It's not their main area, so they don't know or advise on the subtle issues that are involved with things. So for IRA, for example, so Mike, while he was still single, I mentioned these are two families that came together. So if he was single before, named the three adult sons, Greg, Peter, Bobby, as the beneficiaries on his $700,000 IRA. Later, he was married to Carol. After his marriage, Mike didn't go to an attorney. A lot of people decide that the price of attorney is a little high. So he did it on his own, got a little LegalZoom or a will maker or some other program, and just drafted a simple will. I leave everything to my spouse, and she doesn't survive me, then to my sons. So that made Carol think that she was taken care of. And this is a typo here. So it meant to say if Mike never changes his beneficiary designations on his IRAs, those items pass outside of your probate estate. So even though he did this will, leaving it to Carol, the beneficiary designations weren't coordinated with his real plan. So the form is what actually controls where that money goes. Form will pay $700,000 to the three adult sons on Mike's death and not to Carol. But note, that may or may not be what he wanted. So in a blended marriage situation, maybe that is exactly what he wanted, and he wanted some other property that maybe had a house in his name or a bank account in his name or something else that he wanted to go. So don't know in and of itself whether that's good or bad, but the point is that is something that would have really needed to be discussed to make sure it was understood how things would flow. Now, putting an elder law spin on it. While Mike was alive, he has this beneficiary designations, three sons. If he had a stroke and became incapacitated, the question is, what happens? So there's two usual scenarios where we see the problem. Either someone never had a POA, so no one has the authority to update the forms. And if you don't have a POA, you have to go to court to get that guardianship conservatorship I mentioned. And those situations, you have to have court-appointed authority in order to update, to do what's called estate planning. You have to request it from the court and then justify it to the court why it should be done. And sometimes the court won't allow it. Other times, people will execute a power of attorney. Like I said, maybe he went the DIY route, printed up a power of attorney, didn't understand what powers he was supposed to give. If you give the general power of attorney, I hope you have seen the power of attorney in some form, you usually have a list in the general powers section, which is first, and it says real estate, goes taxes, business, banks, it has retirement plans, that's all these different categories. And at the bottom, it says all of the above. So what happens a lot of times is people want to do the simplest thing, give their agent the most powers, and they'll go to that general section and say all of the above. Well, that general section doesn't allow you to update beneficiary designations because the state legislatures understand that updating a beneficiary designation can change hands with a lot of money. So even if Mike did a POA, if he didn't give it the proper powers, it would not be able to update the, Carol say she was the agent, she would not be able to update the beneficiary designations. They would still bypass his estate and still go to the sons. Again, that could have been what he wanted. He may have said, I don't want to grant those special powers to allow her to do it. Or maybe he did intend that and he didn't get a chance to. So that's the things we want to start thinking about as an elder law attorney, talking to people is, okay, what exactly is your intention? what happens if one of you becomes incapacitated? What powers do you need to not only sustain and maintain someone's life, but maybe do some things for them that they didn't get a chance to do while they were competent? I wanted to give a little example also, the difference between the IRA designation and a 401k. Same scenario, while he was single, Mike had his beneficiary designation on his 401k to his 3 sons. After his marriage, he did think about it and he said, you know what, I'm going to put something together, a revocable trust. It comes with what we call a pour over will, like you're pouring a drink. And it says, anything I didn't get a chance to put into the trust while I'm alive, take my probate estate, put it into the living trust. Same terms as his original will would have had. Everything to Carol, she survives, if not to the adult sons. Again, anything with a beneficiary designation bypasses both his will and his trust. So that will and trust don't come into play. But there's an extra element here. A 401k is an ERISA plan. So there's some spousal protection rules. So whereas the IRA would have completely left Carol out if it wasn't changed, the ERISA has protection to say the spouse has to at least get 50%, regardless of what the designation says. So at least there's something that operates in that context to have Carol get 50%, 350, the sons get 350, okay? Where we then put the elder law spin on it, again, if Mike has a stroke, Mike executed the power of attorney, Nate gives all those powers above, including the retirement plan. What does that mean? So it's the same answer in Georgia and North Carolina, because we have in both states adopted what's called a Uniform Power of Attorney Act. So there's some similar thoughts on how those powers are granted in respect to retirement plans. How does this play out? In the beneficiary designation mentioned, no one may be able to change the beneficiary designation. So it's going to be whatever it is. But if I have POA for a retirement plan, even though I don't have the special powers to do the changing of the form itself, I have powers to actually remove money from the plan itself, right? So nothing's changed with the form. The form can say all to my 3 sons, all to my wife, all to half 50% the wife, 50% the kids, or whatever I want on the form. But the actual cash, the POA on the general powers, when I gave all of the above, that actually does allow me to take out and withdraw. So if Mike gave Carol POA and Carol says, whether it's the IRA or the 401k, I don't feel like sharing, or certainly IRA, I don't feel like being left out, she doesn't have to change the beneficiary designation. She can just withdraw the funds out and move it somewhere else, okay? So we have to be cognizant of that. And similarly, the kids, they had this 401k to themselves, $700,000. They realize ERISA will leave $350,000 to the spouse. So they might say, if they were elected agents, let's take that money out and move it somewhere else. So you have to be cognizant of these things that happen when you start giving out power of attorney. Incapacity issues. So I kind of put 3 of these together. Health, that's the advanced directive, right? Your legal capacity counseling, your power of attorney, and then fiduciary representation, guardianship. So in this example, say Carol, and assuming Mike has moved on, passed on, Marcia calls attorney's office requesting appointment for her mother, Carol Brady. And this happens a ton. The child will call and say they need to do estate planning for their mother. And then in particular, says, I think mom needs, a trust. Are there any concerns here? Well, the number one concern that I would have is, why is mom not making the call herself, right? Is she doing this as a matter of convenience and just letting Marcia make the call because she just doesn't want to handle it? Or is there a situation where mom's health is actually to the point where she can't actually initiate the call herself? So what happens here from the start is I'm going to say, yes, Miss Brady, meaning Marcia, I will meet with your mother, but she's the client. So you have to identify who the client is. And I will need to meet with her alone. Why do I need to meet with her alone? Because I need to assess her individual capacity to do anything without that influence of another child around. So that's really where we start to hit some of these elder law issues above and beyond the documents, because a lot of the clients are document oriented, but we are process and ethics and focused on making sure that we are really in a protective role. If I get to the point where I say, okay, I meet with Mrs. Brady, and I think she is competent to actually do a consultation on her own and have that conversation, we still have another issue. She may have capacity to do certain documents, but not others. There's testamentary capacity. That's the lowest level in estate planning, where someone has that capacity to do a will. You don't need to necessarily know, according to our ethics rules as attorneys, all your property in order to do a will. You just need to know what you want to do. I want to leave my stuff to my kids. That's enough capacity. As long as they can say that. If you ask them particularly what they own, they may not be able to tell you, but testamentary capacity, as long as they say, I want to leave my stuff to the 3 kids, and I'll ask them usually how many kids you have. If they give me the right answer, I'm okay. Contractual capacity, that's higher. Okay, you need to have a lot more comprehension in order to enter into a contract under the law. So how does this fit into, for trust in particular, where people are coming a lot of times, they hear about trust because they're trying to avoid probate. So they say, I want to create a trust. If Mrs. Brady is in the state of North Carolina and came to me, I can do that trust under the same capacity that I would have been able to do a will. So if she just says, I want to do a trust for my kids, and she names them, I'm fine. Georgia does not follow what we call the Uniform Trust Code. We have a higher capacity for doing trust. So if she comes into the office and she says, I want to do a trust for my kids, and I start asking questions and she can't tell me what she owns, she has not met that higher level that Georgia requires. So these issues come into play that elder lawyers are more familiar with than some estate planning attorneys or people who are not really estate planning attorneys, but just draft because it's an extra practice they're adding on, and it can cause a lot of problems later. So long-term care, this is really, when you hear elder law, of course, you're thinking health, long-term care, how do I pay for it? Public benefits advice, special needs counseling is going to come into play, and of course, regular legal planning, wills, trusts. We're going to talk about that. Most people, they cannot live an extended period of years with a long-term care expense that is ongoing. Most people, they will drain their life savings, a lot of them within a year. But even if they had more assets, even if they could sustain themselves for an extended period of time, it will substantially drain the amount that they would have left under their will or trust. So a lot of times we have people come who realize, okay, I have something I want to leave, whether it's house, bank accounts, other things. But if I stay the course that I'm on and I have the need for care at home or need to go in a nursing home, and they find out the cost is usually in Atlanta, anywhere from assisted living, probably $6,000 a month, nursing homes, probably 9 to 10,000 a month. So when they start doing that calculation, they start to realize if this lasts 2-3 years, it will drain a substantial amount, if not all of their savings. So then they realize they need to come talk to the attorney and say, how can we protect some of these assets, and how can we do it so that we're not in trouble, and then also maybe have some control, like their regular estate planning, over the course of the assets once they actually leave it to someone. Medicaid is the mechanism that most people will need to use. Private pay is one aspect. Medicare is what people have usually from working a certain amount of credit hours during their life, but Medicare is not going to cover what's called custodial care. Most people who are in a situation of long-term care, they need care where they are being assisted with activities of what we call activities of daily living, maybe toileting, transferring, moving from place to place. So getting dressed, those things are not going to be covered by Medicare long-term. Medicare will do it on a short-term basis. So say you went to the hospital because you fell, Medicare will cover the surgery. And then if you have a need for a skilled nursing facility for, say, some rehabilitation, they will cover that if you stayed in the hospital a certain amount of days before going in, and some rules, but they will cover it up to 100 days, fully for the first 20 days, and then you do a copay, day 21 to 100. But that doesn't mean you get 100 days, it means you get up to. So what happens a lot of times, someone's maybe a day 28, 30, and then someone comes to them and says, hey, you're not going to get Medicare anymore because we don't see the progress, and it's a obviously a stressful thing. If you don't have private pay and you don't have Medicare, what you usually will need to do is have Medicaid. Medicaid is a federal program, but it's administered by the states. So it's a joint federal state program, and the states can pick their particular aspects of the program. There's some flexibility of how they define it for themselves. We'll go through some of those issues. But the key here I wanted to mention here is the assets and income requirements are required for Medicaid. You don't get it from just working a certain period of time like Medicare. Okay? So in our example, say Carol Brady's age 70, so this is 8 years before the other time that they were in the attorney's office, and Mike's still alive. Mike's 75. They come in together and say, we want to plan for long-term care. Mike is starting to have some healthcare concerns. We do an intake form, whether it's an estate planning client or an elder law client. I want to know what the assets are, because I can't help you with just generic, talk. I need to understand how your assets are owned, how much you own, and then that will tell me some options from there based on what you have. The couple indicates that this is a second marriage for both of them, and they have a prenup in place. Okay, Mike has diagnosed with early signs of dementia. Couple wants to plan for the future. What are the concerns? The number one concern people don't realize, Medicaid looks at your assets as a unit, as a couple. Okay, so even if amongst yourselves you have a prenup, or you took lengths that, I have a separate account here, and you have a separate account there, and you operate separately, you don't touch each other's stuff, Medicaid does not respect that. They will view you together, and the rules will pull in the assets of the healthy spouse, even if the couple had an agreement that they would keep their stuff separate. And that can cause a tremendous problem. So here's an example of a sheet that I would see. I have a special program that I call Decision Vault. They'll complete it and they'll give me a printout like this, and I'll share it with the client. We'll go walk through it. So primary residence, bank accounts, you'll see primary residence is joint bank accounts. You have joint and separate. Brokerage account, it's in Mike's name alone. Carol Brady's the beneficiary. So in our first example, that would pass outside the probate estate, but when you're in Medicaid planning, that's going to be Mike Brady's asset. Cars, automobile, two of them, one in each name. Life insurance, Mike Brady has a life insurance for a couple of million. It's a permanent policy. So that means it probably has some cash value. That's going to come into play in Medicaid because it will be viewed as an asset. And then the 401k, depending on your state and depending on which spouse goes in, that may or may not be a problem. So we're going to kind of look at Medicaid purposes. Assets are in two different categories, exempt and countable. So the main assets that are exempt, your primary residence, one vehicle, okay? So we're talking Mike and Carol Brady. So when they go in, if Mike is the one that's going on Medicaid, their primary residence will be exempt. Mike's vehicle that's in his name is exempt. The vehicle that would be in Carol's name is not. Household furnishings and appliances, they usually don't worry about your personal items and effects and things around the house. They will if it's something that can be potentially sold and you have some expensive collection or something and some valuable rugs or something like that. Life insurance, funeral expense trust, they usually have some exemption, but it's usually a dollar amount. And life insurance, that's term is not considered an asset. That's so that's going to be exempt. But if you have a permanent policy, they will count the cash value above a certain amount. Depending on each state, they'll set that level. So if Mike had a term policy, we wouldn't need to worry about it at all. With a permanent policy, we then need to know how much cash value there is. Countable assets, of course, cash, checking, savings, always going to be countable. CDs, money markets, still countable. Sometimes, people have CDs that say they can't access it for a period of time without a penalty. Does not matter with Medicaid, your penalty is not included in their consideration. Stock, bonds, mutual funds, that also, so say someone has retirement account IRA and things like that. If you have a traditional IRA that will have a lot of tax when you withdraw it, again, they don't take that into account. They will use the top value. So kind of wanted to get this illustration. IRAs are a big planning issue when I have a Medicaid case, because some states like Georgia, you see here in black, IRAs of both spouses are exempt. By exempt, they mean you have to take the IRA for the person going in and convert it from an asset into an income stream. So if you had the $700,000 IRA and weren't taking payments from it, it will be countable for Mike. But if I make it required minimum distributions, whatever that calculation is, and he's taking, say, $20,000, $30,000 a year out of it, that's no longer a countable asset. It would be exempt in the state of Georgia. But if you are familiar with the states, you see here's North Carolina, IRAs of both spouses are countable. So if Carol went in Georgia, Carol has no IRA to even be concerned about. But if they lived in North Carolina, Mike's $700,000 IRA would be countable and have to be used for her care and would have to be spent down. So there's tremendous consequences moving between states. A lot of times when people get older, they're thinking about other things and how they move. Obviously being near family, maybe cost of living, weather, other things. But Medicaid rules, depending on their assets, could have a devastating effect going from one place to another. I wanted to print this so people kind of understand with Medicaid, when the attorney is helping you, there's different rules I mentioned for each state. I kind of illustrated the IRA. There's some general rules that are same across states. The person who's going in, individual resource allowance gets $2,000. That does not change unless certain states like California and New York has some special things, but for most states, we're looking at $2,000. If both people go in, husband and wife go in, then it's 3,000, but we're usually looking at one person going in and one person staying at home. Person staying home, we call the community spouse. The income side of things is based off of that particular state's rules. Some states like Georgia are called income cap states. You have a number that they give you, which is 3 times the SSI limit number. So SSI limit number is 914. So 3 times that's 2742. As long as your Social Security, pension, require minimum distributions from your IRAs and whatever other things you have coming in as income, if all that is under 2742, you will qualify for Medicaid on the income side. If you have 2743, you will not. It says hard cap. That's why I call it income cap state. That does not mean you can't qualify for Medicaid. You just can't qualify unless you don't go the extra step. The extra step in Georgia is what's called a Miller Trust. So if someone had, say, 4,500 of income, we would then say, we're going to use a Miller Trust, put the 4,500 in the Miller Trust. Georgia Medicaid would see the Miller Trust each month, receive the 4,500, and basically let the person qualify, keep the 4,500, and then they've satisfied the income. North Carolina, you'll see income regulations, you don't see a number because North Carolina is not an income cap state. They have what's called a medically needy state. So they make you spend down on medical expenses until you reach a certain point, and then you can qualify. So each state has these different rules that come into play. So you need to seek some help trying to make sure you can, and these change every year. So you see at the bottom, Georgia was updated in April this year, North Carolina in July. Spousal and private standards. So this person who's going in gets $2,000. The community spouse in Georgia gets to keep another $148,620. Now remember, this does not include your house, which is exempt, does not include your car, which is exempt. Potentially, if the community spouse has an IRA, it will not include that. So the community spouse could have a $500,000 IRA, won't be looked at. So there's a lot of assets you can keep. And then on top of that, you get to keep another $148,620. So if they had bank accounts, brokerage account, other things, they could keep $148,000 of value. So that extra car the community spouse had, that would be countable. She could keep it under the $148,620. Move over to North Carolina. You see 2 numbers, a minimum resource allowance, $29,724, and a maximum, $148,620. North Carolina does not do what Georgia does. Georgia automatically gives the community spouse all $148 as an option. What North Carolina does is what's called a 50-50 state. So in this situation, if someone had, for example, $150,000 extra assets above the house in the car, in the state of Georgia, they would get, actually, let me say 155. The person going in would get 2,000, which leaves 153. The community spouse would have 148,620. And that extra, 4,380 would go to the state that they'd have to spend down before they could be eligible. North Carolina, if they had 155, then the person going in gets 2. That leaves 153. Because it's a 50-50 state, they take the 153, divide it by 2, and now they can only keep $76,500 as a spouse in the state of North Carolina. So you see 76,000 versus 148, right? Tremendous difference. And in addition, North Carolina does not exclude the IRAs for both spouses. So North Carolina is far harder and far more devastating to be on Medicaid than in Georgia. That's why we want to talk to people up front when people come in and say, I just want a simple will or a revocable trust. A revocable trust is a countable asset. Anything I can get my hands on, this Medicaid people will consider it mine. So if it's in my own name, if I have a house that's in my name, it's considered mine, but it will be exempt under the Medicaid rules. If I do a transfer thinking I'm going to set this revocable trust up for probate, I'm going to do a transfer from my name to the trustee's name, and that way it's out of my hands, right? I'm avoided probate. I'm thinking I did okay. If I get sick later and need Medicaid, Medicaid considers everything in a trust available. So that house that was formerly exempt is now not exempt. So this is a tremendous problem where I talk to people and they don't realize that there is a world of hidden landmines in their planning. So I definitely just wanted to bring that up. I wanted to bring that up to people just so that they are aware. I think I'm frozen here. You tell me what slide you see, because I can't see what slide I'm on right now.
It's still the one that you had up earlier where it has Georgia on the left and North Carolina on the right.
All right, thank you.
You're welcome.
I'm not sure. I'm trying to move to the next. Okay, so we're back here on the next slide. You see the slide again with the assets?
Yes.
Okay. So both states, house, if it stays in their name, will be exempt. Depending on who goes in, the asset will, definitely be in one spouse's name or the other. The spouse who doesn't go in might be able to keep some of this from the community spousal resource allowance. The brokerage account definitely will be counted towards Mike, him going in, but either way, assets as a couple. Carol will still, if she goes in, be considered as having that asset available. None of these assets will be exempt in any way. They each get one car, so whoever goes in gets their car exempted. The other spouse's car will be counted against them. Mike Brady has a permanent policy. I would need to get a statement from Mike. How much is the cash value? That cash value will still go towards that $2,000 limit. So if someone has, $3,000 in the bank and $10,000 in the cash value, Medicaid looks at them as having $13,000. 401k plan, again, this is going to be exempted in Georgia. If it's Carol going in, Mike will have it exempted. It won't be part of Carol's calculation. If Mike goes in, as part of his calculation, since it's his, he would have to make it an income stream requiring minimum distributions. If it's North Carolina, it doesn't matter which spouse goes in, it's going to be countable. Okay. So I kind of want to leave it there. If there are any questions, I don't. So feel free if you have any questions. I know it was 11:04. So I thank you for hanging in there with our late start. Did anyone have any questions?
I don't. Thank you for asking.
Oh no. Well, thank you. Thank you for joining. I apologize for the connection issues in the beginning. If you need to reach me, here's my contact information. And I plan to do this at least once a month. So if you have some people who weren't able to make it today, please feel free to let them know it's coming again and have a chance to hop on. Okay? Thank you very much for joining and enjoy the rest of your day.
Thank you. You as well. Thank you.
Thank you.